It is my true honor to moderate this panel of copyright experts and discuss a topic near and dear to my heart, which is conceptual art and copyrightability. We're going to start off with Reagan Smith. Reagan is the General Counsel and Associate Registrar of Copyrights for the United States Copyright Office, where she provides, obviously, legal guidance to the various divisions and programs, including the recordation and registration systems. Then Amelia Brankov is going to talk about how a practitioner deals with a conceptual arts clients. What are you looking for when you're drafting agreements and your client is a conceptual artist or is commissioning a piece of conceptual artwork? She's counsel in the litigation group at Frankfurt, Kurnit, Klein, and Selz. Shyam Balganesh is to Amelia's left. Shyam is a professor at the University of Pennsylvania Law School, and we are thrilled that he is visiting here this fall. And his scholarship focuses on the use of private law and how private law can impact intellectual property law. And Shyam is going to talk a little bit about authorship and what authorship is, and how it can be defined and how it's transforming. To his left is Chris Buccafusco. Chris is a professor of law at Cardozo Law School and director of their IP and information law program. And Chris is known for his work using empirical tests to investigate the impacts of and interpret IP laws. And finally, Bob Brauneis, all the way on the end, the professor and co-director of the IP program at George Washington University Law School, is going to present his take on, I'm sorry, I'm totally blanking. Yes. Sorry, Bob. And Dynamic Works. And Bob was the inaugural Kamenstein Fellow at the Copyright Office in 2013, so he has a unique perspective of being in and out of the Copyright Office. So I'm going to hand it over to Reagan.
Thank you, and thank you for having me here. You have just heard from our registrar, Karen Temple, a little bit about how the office approaches its statutory duty of determining whether works are copyrightable in the administration of its registration program. Of course, determining copyrightability of most works is quite simple, and the office does not need to correspond or worry over the mine run of applications that come in to determine whether they possess the creative spark necessary to register a copyright interest. As the Supreme Court has noted, the requisite level of creativity is extremely low, and the vast majority of works make the grade quite easily. But one of the most interesting parts of our job emerges when the works does involve types of authorship that challenge that standard, and that's sort of what I would like to run through today. In her introduction, the registrar outlined the functioning interactions of the registration program, which is run by Rob Kazanik, and the Copyright Office Review Board, which hears the final request for reconsideration of refusals to register a claim for copyright. As a member of that board, along with the registrar and Katie Rowland, we have seen some interesting claims, and I'm going to touch briefly upon a few of the typical and not quite so typical cases we are asked to resolve. So starting with the typical, many of the rejections on the basis of copyrightability involve considerations such as whether one is trying to register a common shape, symbol, or a design, a word in a short phrase, a typography, a useful article, some of these doctrines that June discussed in her introduction. And the standards for copyrightability are codified in 37 CFR 202.1. It's entitled Material Not Subject to Copyright, as well as other parts of the law, and it's explained in the Copyright Office Compendium. So pictured here are a few recent refusals of claims upheld by the review board on these grounds. So the top left, you see a logo for the Periscope company, which was denied as a common shape or design as a variation of a standard map pointer vector. Directly below that is a flag for the Tommy Hilfiger company's logo, and the Copyright Office denied a claim to copyright in that, saying it was an uncreative combination of rectangles, and it was also described as 3 pre-existing nautical flags from the nautical flag alphabet for the letters T, J, and H for Thomas Jacob Hilfiger. Other examples on here were rejected as a word or a short phrase, a typography that was in non-English font, or as a useful article. In considering these applications, the Review Board and the Copyright Office generally takes pains to faithfully apply the law and stay true to its practices. A lot of these practices are illustrated in the compendium, and these examples are sort of interspersed with some language for it. And in this case, this says, in some cases, there may be only one way or limited number of ways to express a particular idea, and the office will not register a claim based solely on standard expressions that naturally follow from the idea of a work of authorship, such as a sculpture depicting a brightly colored jellyfish swimming in a vertical orientation. And if you're here at this conference, you've probably figured out that that example comes directly from the Ninth Circuit's opinion in Satava versus Lowry. So on the left is the Satava's glass and glass sculpture of jellyfish, and on the right is Christopher Lowry's Second Comer artist sculpture. And as the Ninth Circuit said, clear glass in this case was the most appropriate setting for an aquatic animal. A lot of the choices to have it vertical, to have it with bright hues, the proportion, lacks the quantum of originality needed to merit copyright protection. And if Satava had made some copyrightable contributions, if they were not governed by the jellyfish physiology or glass and glass medium, they may protect it through copyright, but it would only be thin. So taking that, the Copyright Office applies this standard. The compendium elaborates also, we will not protect stock characters, settings, or events. Comment to a particular subject matter. And how did we apply this? We rejected an application to register this. We determined that a pool float depicting a basic slice of pepperoni pizza was just simply too basic. Neither New York style or deep dish, not browned, not bubbling, not very many topping combinations. The work's elements were just not protectable because the combination was an entirely standard and commonplace representation of a slice of pepperoni pizza. And if there had been more creative expression, those elements may have been protectable, but in this case, this did not make the grade. Now we move on to the log cabin, and I will say maybe at lunchtime, Katie and I can share our own log cabin photo collections with June because we feel her on that. But we have to apply the same standard regardless of the commerciality or artistic reception in a work. So just as the registrar explained that the office must determine whether there is copyrightable artistic authorship in logos, regardless of whether or not it is a strong trademark, it shouldn't be a surprise that the Copyright Office looks at conceptual or participatory art from a copyright perspective. We are sometimes put in the odd situation where we have to say, well, this may be art, but is it copyrightable? And it would be wagging the dog from the perspective as administering the copyright law for us to flip that question. So this is the deposit that came in for artist Katie Nolan's sculpture Log Cabin. And the application said she is trying to showcase the failed promise of the American dream through this installation. It was interesting because it made clear that the specific logs were not part of the deposit because the logs could be changed in and out. However, the overall structure of it was. And the office said this is ultimately a simple representation of a standard log cabin facade with joinery, and any authorship was de minimis and did not support registration. And we actually looked into what is the standard depiction of joinery in a log cabin, and this is it. The letter went on that just because it's not functional and useful is irrelevant. It is ultimately an expression of rote designs and representations of the log cabin. And so, although there's interesting conceptual choices, it may well be art. We did not register this claim to copyright. Next, we also will not register works produced by a mere mechanical process. So this is a photograph of the sunset at Mount Fuji, and we would register this, but that is not what we were asked to register. Instead, we were asked to register something called a lumen script by a company called Telelumens, and the deposit is here on the right. This is an electronic data file. There were two of them. One was trying to recreate the light conditions on the peak of Mount Fuji, and another that was recreating a sunset, an actual sunset, although it was not clear which sunset. And they claimed it was a computer program. And so we looked at the deposit that we got, and it is a list of numbers. It was not code because it was not a set of instructions that would directly or indirectly bring about a result under the Copyright Act. Although the applicant said sometimes their lumen scripts include commands or looping or branching or subroutines, this one did not. So we said, well, this just is not a computer program. This is a formatted data input file. So the applicant was resistant to having a claim registered as literary text, but we examined it that way anyways. We're trying to figure out whether an application can be registrable under what the Copyright Act will allow. And we looked at it as a compilation. However, a compilation is only protectable if the selection, coordination, and arrangement is not dictated by external factors such that any person composing that compilation would necessarily select those categories of information. We don't register HTML code generated by a website. We do not register, for example, X-ray photographs. And in this case, we did not register the Lumen script. I think that this company sort of makes up their own ideas of light situations, and maybe we would register that, but in this case, although we would register a photograph of Mount Fuji, we did not register this deposit. We also will not register works produced by nature, animals, or plants. These are dinosaurs. We did not register these dinosaurs. Even if the prehistoric fossils could be copyrightable, I think they would probably be in the public domain. That is a joke that arguably gets to the heart of the matter, but if the claims were a little more involved. In this case, both claimants made similar arguments. They argued that the fossils themselves were incomplete, so there were certain fill-ins of the bones or replicas that had to be added in order to assemble the dinosaur. You have a Stegosaurus and you have a Hadrosaurus here. And they also argued that the compilation of assembling the bones into the dinosaur was copyrightable. And we rejected both of those. We said that the creation of the replicas and the bone fill-ins was dictated by the need to replicate the physiognomy of the dinosaurs. And it turned out the hadrosaur, this is basically like the pigeon of dinosaurs. There's a lot of hadrosaurs that have been constructed and replicated, and this is sort of standard fare for this. So we rejected both of those claims, and we made no bones about it. Okay. All right, it's early. This is a fluorescent fish. It is genetically engineered to glow under artificial light. And the applicant said, similar to a painter using paint on a canvas, the paint is the non-native DNA, and the canvas is the zebra danio fish. And we examined that argument, and we examined things such as the Kelly decision that I think others may talk about, which we said did not actually concern whether a living thing itself could be artwork, which was this claim. And we said genetically modified living things do not follow under the category of enumerated authorship. Fishes are subject to forces of nature, such as feeding habits, levels of nutrients, water, age, all of that will affect their appearance, and so we did not register that claim. Similarly, this is a mutated poinsettia, and we did not register the claim to the process for genetically mutating a poinsettia, and we kindly pointed the applicant to the Patent Act. This is a deposit of a sculpture in DC that combines geometric shapes. There's triangles, greens, a pole, there's circles up the bottom, and there's circular holes into the design. On the right is what it looks like when it is installed. There's also running water and there's glowing lights. We looked at this by stripping out the water elements and the light elements, and we looked at what's left, and we registered a claim to what's left, finding it was just over the line. So I'm sort of interested to see, because I think that is how the office does cope with art pieces that incorporate transient or participatory models. We sort of look at the parts that are there that can be protected under the Copyright Act and see if it is enough. Very quickly, I will run through a couple choreography cases which are interesting. Choreography was protected only in 1978. It is choreography and pantomime. It is the composition and arrangement of a related series of dance movements and patterns organized into a coherent whole. We, in evaluating these claims, we have looked at 102A as well as 102B, and in the case of the Bikram yoga design, did not register it, I think, as a unprotectable exercise routine. This one is interesting. This is a man who tried to register a series of sports end zone victory dances strung together. So it was the Desmond Howard pose, the Icky Shuffle, the Funky Chicken, a football spike, and some other moves that I'm personally less familiar with, but a lot of people were, new. And we said this was a fairly haphazard collection of routines and dance steps not connected except for sports. It was unprotected. I think this is interesting because if it had been a little more connected or organic, it might have made a difference, but I've watched the video and that's not what was going on here. And just to set up, most recently in the news, there has been litigation over moves in Fortnite. On the left, you have the deposit, and on the right, you have the emote or the move that is incorporated into this video game. The next one, you see the floss. This deposit came in as just one move, and I think this will play. Okay, he's flossing, so. And then on the right, this is just an expert. It was a longer piece of a deposit called Carlton, which you may recognize from the Fresh Prince of Bel-Air. If you recognize that, you would wonder whether Running Man was the or was not the Running Man But at any rate, we looked at each of these registrations as they came in based on the deposit that was submitted and the type of claim. And I think that's really the takeaway for how the office approaches these. One of the applications came in as a motion picture, and we registered that, but with an annotation saying this is not extending to your individual dance steps. In some cases, there were longer pieces that we determined did qualify as choreography, but again clarified in an annotation that the individual dance steps remained unprotectable as choreography. So in each case, we look at what comes in, and that is a quick tour of how we approach things at the Copyright Office. Thank you.
Good morning. As part of my law practice, I am often asked to counsel clients concerning the purchase and sale of works of art, and questions about the copyrightability of these artworks come up in various ways. Unlike some other forms of cultural production, the main way visual artists benefit economically from the production of their work is not from royalties from the sale of copies of the work, but rather is from the sale of the physical artwork itself. Perhaps that's why, putting aside photographers, visual artists don't commonly register their works in a routine manner. Registration certainly exists, but it's not an artist's everyday practice to register a work after it has been created. This can be frustrating because when considering whether and how a work is protected by the copyright law, one of the first things lawyers do is look to see whether there is a copyright registration for the work. So when you're counseling a client about whether a particular artwork is subject to the copyright law, you typically have to go back to first principles. We know from Section 102 of the Copyright Act that copyright covers original works of authorship fixed in any tangible medium of expression. So from that, we know that we need the work to be 1, original, 2, have an author, 3, be fixed in a tangible medium of expression. Some artworks that our clients are selling and creating will easily satisfy this test. Traditional paintings and sculptures generally are easy cases. There seems to be little question, for example, that a painting by Norman Rockwell or by Jean-Michel Basquiat would satisfy this test. But this doesn't really describe the totality of the works in the marketplace today. Many of the works that have 6, 7, and even 8-figure values today don't look like a portrait, landscape, or sculpture. Consider a rope piece by Richard Tuttle, an abstract work with geometric shapes by Ellsworth Kelly, a work with one word or short phrases such as the works by Christopher Wool. Consider works based on interactive experiences such as Random International's Rain Room, which allows visitors to experience walking through rain without getting wet. Consider also light installation works such as Aten Rain by James Turrell, which was on display at the Guggenheim Museum in 2013. As practitioners, we appreciate that copyright law has limits. Ideas, basic phrases, shapes, those are not copyrightable. And that is for good reason, because nobody should have a monopoly on these basic building blocks of expression. Our artist and gallery clients understand that not all artwork can be copyrightable. But when it comes to their own work, artists tend to assume that the law will cover their work, even if they have never sought to register their works. So when artists are at the point of talking to me as a lawyer about this, it's either because someone has infringed on their work or their intellectual property rights are somehow otherwise at issue, such as in the context of the negotiation of a commission agreement. As a copyright lawyer analyzing these issues, we can look to case law, reported cases from the past year, to show that courts generally hold that the level of originality required is a very low bar. We can look at Pohl against MH Sub 1 LLCR, a recent case from the 11th Circuit, holding that before and after photos of dental patients' teeth can be sufficiently original to merit protection under the Copyright Act. We can also look to Silvertop Associates, Inc. versus Kangaroo Manufacturing, Inc., a Third Circuit Court of Appeals case, which may be discussed later in today's programming, to see that a banana costume is sufficiently original to warrant copyright protection. Well, so far so good, right? It would seem that we would be on good ground to tell our artist clients that their iconic works would receive the same treatment as a picture of teeth taken by a dentist or a banana costume, right? Well, not so fast. Under the copyright law, the issue of a work's artistic merit is irrelevant to the issue of whether the work is sufficiently original. Rather, the Copyright Office is only to look at the appearance of the work to determine whether it is sufficiently original. Two examples of registration refusals of works by significant artists teach us to proceed cautiously when counseling clients. The first is Log Cabin by Katie Nolan, which you've already heard about and probably will hear more about later this afternoon. The second is the well-known work Oi Yo by Deborah Cass, which was also refused registration on the grounds that it was not sufficiently original. Some think that the issue of whether art is subject to copyright protection is outmoded, and that market forces can effectively address these issues. But that, of course, can only occur when the market works efficiently. Without copyright protection, an artist does not enjoy the exclusive right to reproduce the work or prepare derivative works. Although artists primarily do earn money from the sale of their work, some artists have significant streams of income from licensing. Furthermore, artists need the copyright law to police infringement. Apart from economic damages for infringement, artists care deeply about their legacy and do not want their artwork to be used in ways that are not in line with their views. There are two recent high-profile examples of this. The first is the lawsuit that Anish Kapoor brought against the National Rifle Association for its use of his artwork, Cloudgate, which is known in Chicago as The Bean, in a pro-gun advertisement. The second is a lawsuit filed in Denmark by artist Ai Weiwei against a car distributor for featuring his artwork Soleil Levant, comprised of thousands of bright orange life jackets worn by refugees and migrants in a car ad. Furthermore, the Visual Artists' Rights Act, which affords certain moral rights to authors of works of visual art, only applies to works that are copyrightable. From all of this, there is clearly a tension between the rights of artists and the law, and sometimes we cannot clearly counsel clients one way or the other on their rights under the Copyright Act. Even without having all the answers as to copyrightability, though, we can do some things to protect artists. For artworks where it is not obvious that copyright law would apply, artists can protect themselves through contracts. They can prepare commission agreements and purchase agreements restricting the purchaser's right to publicly display works and reproduce images of the works. They can also specify in their contracts what the purchaser can do in the event the work needs to be restored or needs to be moved. Finally, perhaps artists can be encouraged to seek registrations for their works. That way, they will know what their rights are, and there will be a more robust sense of how future cases will be determined. Thank you.
So thank you to the organizers for having me. I'm delighted to be here. I'm going to take a step away from conceptual art and go a little bit into history and a little bit into doctrine and do the usual law professor thing. We law professors like to say, one of the great things of the job is that we get to overrule the Supreme Court 10,000 times a day, but the bad thing about the job is no one cares. And so I'm gonna try and make this such that you care. And here's the core idea that I want to suggest, that one of the concerns that we have with conceptual art going forward and the question of copyrightability is that copyright law has for a really long time now had a nascent and unstated theory of authorship that connects to the way in which we conceptualize the connection between inputs and outputs, agency in the real world, and the nature of the human connection to the work, that these works are calling into question. And part of the concern is that this test and this conception being unstated, when we take a step back to try and understand how we might update it or liberate it from these conceptions, we have a hard time wrestling with it to nail it down. And so what I want to suggest is leave you with the question of whether it's time to update our traditional conception of authorship. But to do that, I want to start by saying that we do have a traditional conception of authorship hidden in plain sight. So authorship, as we know, is not a doctrine that is well defined in copyright law, but it does a significant amount of analytical and doctrinal work. The idea of authorship is in many ways embedded within other well-worn doctrines of copyrightability, within originality, within fixation in different ways, and very much within copyrightable subject matter. So it's hiding in plain sight. The rhetoric and the notion of authorship is doing a lot of analytical work in a variety of cases. Certainly, I believe, in the way in which the Copyright Office approaches this, at least in my reading of parts of the compendium. So it's diffused in significant portions of the compendium, but I wanted to focus on one part of the compendium where I think the notion of authorship it plays a fairly significant role in important intuitive ways that are unstated and not fully expounded, which I want to explore. And Karen already touched on this, which is provision 313.2, which says a few different things that I want to highlight. It says to qualify as a work of authorship, a work must be created by a human being. 2, that the office will not register works produced by nature, animals, or plants. Likewise, the office cannot register a work purportedly created by divine or supernatural beings. And similarly, the office will not register works produced by a machine or mere mechanical process that operates randomly or automatically without any creative input or intervention. Now, I've highlighted for you in red the different verbs that this notion of authorship in this provision about human authorship actually connotes. Now, what I want to emphasize is that there's nothing self-evident about these verbs and the nature of the connection between human agency and the product or the output that is seeking protection that they necessarily characterize. And so let me explain. So in every copyright class, the discussion of authorship in some ways begins with this photograph, Oscar Wilde number 18, of course, right? Barrow Giles versus Napoleon Sarony, which in many ways is the first time the Supreme Court's grappling with the notion of authorship, but through the doctrine of originality and the idea of writings in Article 1, Section 8, Clause 8. And the court, through the parties' pleadings, has a nice detailed description of what exactly it was that Napoleon Sarony did. He posed Oscar Wilde in front of the camera, selected and arranged the costume draperies and other various accessories, arranged to present in a graceful outline, yada, yada, yada. But what it doesn't mention is that Napoleon Sarony had a cameraman standing about 25 feet away from him who actually was operating the early generation camera machine at the time. So Napoleon Sarony was not the cameraman. He was orchestrating the entirety of it. And the court in some ways is aware of this, where it develops the standard of, okay, who is the author? He to whom anything owes its origin, the originator, the maker, or one who completes a work. And drawing from an English case, the court says, whoever is the effective cause of the creation, right? Hidden in that idea of creation, therefore, is an important causal dimension. Now, I don't have to say to all of you lawyers who've taken tort law, when we talk about proximate cause, and I know it brings back nightmares of first-year law school, but the open-endedness of the idea suggests that there's a variety of different connections between input and output that can qualify for the conclusion that you're looking at. And where does this come up? Well, so here are two photographs that I want to put up. Karen already beat me to the punch. So we have our good friend here, Naruto, right? This is the photograph at issue in the monkey selfie case. And you take a look at the photograph on the face of things if you didn't know the narrative behind it, and you compare it to the photograph on the right? And we'll call this individual on the right Baruto. But this is an actual wildlife photograph that appeared in the National Geographic magazine. Right? Equally detailed in terms of capturing the monkey's anatomical features of the face, the monkey's facing the camera, smiling in a similar, I would say, in a more expressive way. And I don't think we would argue that the one on the right has serious authorship concerns or copyrightability concerns in terms of the way in which it was projected and actually produced. But there's something about the one on the left. It doesn't have to do with what is manifest as mute testimony in the photograph itself. It's instead in the narrative of authorship behind the production of the photograph. It's because the person who created it, I'm not going to say the person who authored it, produced a narrative saying that, no, it really was produced by the monkey. I went and spent these weeks getting to know Naruto and his family. I befriended him. I got him to be familiar, that's David Slater, with the monkey, and befriended him and had him understand how the camera works, and then eventually I hid and let them hit the shutter button. But the answer underlying the copyrightability question there is a theory about what kind of human connection we deem sufficient for the purposes of our authorship, right? The answer to why the photograph was not copyrightable as a subject of authorship was because the connection was deemed insufficient as a qualitative matter. And that, I think, is the key point here, which is that when we think about authorship, there is an important qualitative dimension between input and output, between human agency and the work that we have to fully grapple with. We have these intuitions that are embedded within copyright doctrine, and the new kinds of works, I don't want to go over all of them, what Amelia and Reagan talked about, are questioning some of these intuitions. So we leave aside the ones that are firmly on the domain of originality or fixation, but cases like Kelly are really about questioning the connection between human agency and the actual output that is produced and is seeking protection. The problem that we have is in the absence of a clear doctrine or a clear place to grapple with authorship, we're doing the work through these other different concepts, originality or fixation. And so the question that I have, as a suggestion, this is my law professor hat, is perhaps it's time to rethink our traditional conception of authorship. Perhaps it requires in the compendium an actual section that says, what does authorship mean? Rather than what is human authorship, or a diffuse conception of authorship that runs through different categories of works. And if so, then the question is, should we move away from what I would call an epistemic or a real-world idea of authorship, which is looking for tangible external verification of this connection, right? That's what's really doing the work. That can you show that there is a tangible connection between the human agent and what comes out at the end, such that it's perhaps capable of being controlled, capable of being replicated into the future, and therefore capable of being protected, to one that takes note of the way in which authorship and art are working, something of a far more intentionalist, conceptual domain, liberated from the traditional idea. I'll leave you with that question. Look forward to the conversation. Thank you very much.
Whoa, you should not tell a law professor that.
I know.
Buccafusco, that's me. Good morning. Hi, my name is Chris Buccafusco. I teach at Cardozo Law School. For those of you I haven't met, I'd be delighted to have the opportunity to later. Also nice to see former students in the crowd. Hello. Thank you very much to the organizers here at Kernochan and the Copyright Office for putting this together. This is always a terrific event, and I'm delighted to be here and really excited to have an opportunity to talk about this set of issues that I think are really important. And in some respects, what I'm going to do is push on from some of the things that Shyam was just telling you about and continue to give you a bit of my sense of some of the challenges that conceptual art is facing in the Copyright Office, the Copyright Office is facing with respect to conceptual art, and to use these as an opportunity to think about some more fundamental challenges at the heart of copyright doctrine. I'm interested in the relationship between the control or predictability that some putative author has over the content of her creation, and the way in which that interacts with our judgments of its creativity. Right? And what I'm going to suggest is that there is a kind of paradox at the heart of copyright law. And that these cases involving conceptual art demonstrate that paradox pretty clearly, but that actually it exists in a whole bunch of other cases, and that this is one way of seeing it in a particularly stark manner. And so here's the basic argument, right? That to the extent that someone exerts too little control, or too little, or there is too much unpredictability about the way in which the work will be produced, then that person is at risk of being declared not an author of the work, right? So that one of the things that copyright law does is it looks for control and predictability. And if there's not enough control, there's not enough predictability, copyright law may say, and the Copyright Office may say, you are not an author, right? On the other hand, to the extent that there is too much control, to the extent that there is too much predictability, then you as the author run the risk of being told that your work is not creative. That in fact the strategy for an author is to balance these sort of competing requirements between control over the ultimate product, but not so much control that you risk losing the opportunity for creative expression. Right? And so I think by looking at a bunch of cases, we could see how these sorts of things have come out. I think what's basically happening is copyright law has adopted a fairly traditional account from aesthetic theory about what authorship and what creativity are, and that over the course of the last 50 or 60 years, conceptual art in particular has been challenging a lot of those theories, encouraging us to think more deeply about what we understand authorship and creativity to be. Right? So if you think about this, right, so here's a quote from Paisley Livingston, a contemporary aesthetic philosopher, right, and if names are destiny, I think Paisley Livingston was just definitely going to become a philosopher of aesthetics, right? It's just like the only thing he could have done, right? And so to be an author, according to Livingston, is to be in control of an utterance, right? And so the problems for Livingston and others were to think about who, with respect to, say, some multi-person effort, right, can plausibly be the author, right? Does the caterer of a film shoot count as one of its authors? Does the financial backer of a film or a book count, right? And the rhetorical question there is clearly no, right? An author is one who exerts authority over how the work is made, who gets to contribute to it, when it gets finished. This sort of stuff, I think, turns up in copyright law all the time, right? Similar disputes show up in copyright law when the copyright law has to decide who, if anyone, is an author of this work. It looks for who has control over the work. And if one has insufficient control over the work, one risks being declared not its author, right? So take, for example, Lindsay versus the Titanic. We haven't seen this one yet in the slides today, right? So Lindsay here directed this underwater shoot of the Titanic, right? He himself did not die. Wait. Maybe not that one, right? But the other photos, right, were ones that he directed people to shoot, even though he himself did not dive down to actually take the photographs of the Titanic. Nonetheless, the court had no problem describing him as the author. Why? Because he exercised such a high degree of control that it duplicates his conceptions. So he had in his mind some set of ideas about how the literally underlying ship would be expressed in the ultimate images that got produced, and those images duplicate his conception, so he has control of them. On the other hand, in this case, one that doesn't get talked about an awful lot, this is a situation in which someone hired a producer to print off a bunch of maps for her and other sorts of aspects of pictorial work, graphic work. And then the printer tried to claim a copyright, tried to claim also authorship in the ultimate production. And the court says here the printer is effectively an amanuensis of the actual author. The author is dictating what's happening, is in full control of how the work ultimately gets produced, and thus the mere printer of the work can't assert any sort of authority interest because she didn't do anything, she didn't have any control over the work. This shows up, I think, actually, in now these conceptual art cases as well, right? So part of the problem for Kelly, right, and Kelly faced a lot of problems, but part of the problem for Kelly, in the Seventh Circuit's opinion, was that at any given moment, the garden owes most of its form and appearance not to Kelly, right? Kelly doesn't control it, but to natural forces. Though the gardener who plants and tends obviously assists, he merely is, right, he's setting them out there, but then gives away control over them. Right, gives up the opportunity to perfectly prune the work and predict precisely how it's going to go. At any moment, he can't know what it might look like. That is beyond his control, and in this respect, he becomes less of an author of the work. You might think of this in other sorts of contemporary and conceptual art. This is Vito Acconci's film Following Piece, where he would wake up in the morning, grab a camera, and find a random person and follow them on the streets until they went into a private establishment. And so each film is however long that person was walking publicly was. And he just kind of creepily walked behind them. This is like pre-Me Too, right? Like, you don't do these things anymore, right? But like back in 1969, he would just kind of walk behind. And so in this respect, right, this becomes in some respects, and this is like part of the point, the total depersonalization of the work. It is mechanical and irrational. It doesn't require the author to make choices. And that's part of the point for Acconci, right? But also part of the problem that it produces when it comes into, when it potentially bumps up against copyright law. You might also consider this work, Obliteration Room, other sorts of works where other people are an opportunity to contribute to it. The room starts off white, right? And then people are encouraged to put stickers on it, right? And so by the end of the day, it's got lots of stickers, right? And looks like this. To what extent, right? And here the author, right, Kusama, doesn't have control of the ultimate end product. And in that respect, I think, right, runs into problems for understanding her commitment to authorship, her ability to be described as the ultimate author of the work. Nonetheless, the other side of this, right, is this problem that in order to be a copyright-protected author, not just an author, but an author who gets a valid copyright, you have to exhibit some kind of creativity. And I'm going to suggest again that what creativity is doing in copyright law is mimicking what creativity has been doing in a certain kind of fairly traditional aesthetic theory that maybe doesn't line up so well with contemporary artistic practice. Right? So here is Boris Gott, another aesthetic philosopher, who says a creative work is one that is original, valuable, and demonstrates flair. I love that word, right? Like if you're trying to, like, it's great. Like Feist is hard to interpret, and I think like flair is actually a pretty good word for what that second step is, right? We're looking for flair. It can't be made purely by chance, that is to say, without control. It also can't be made purely mechanically or through rote procedure, right? There has to be an opportunity for imagination. So in copyright law, too, it must be original and creative. This means there must be opportunities for freedom to choose, that the work reflects subjective judgment, and that there be some sort of unpredictable spark to the work. These are the terms that Feist uses, these are the terms that the Copyright Office uses, and others use, right? There must be, I guess I'm reading this as saying, there must be something unpredictable, right? There must be something that like we didn't see coming, some flair, something unusual, something like garden variety, right, and the like. One of the ways this gets cashed out in copyright law, in a way that I think is kind of interestingly problematic, is the way in which the courts, or at least some courts, and lots of copyright scholars and thinkers analyze creativity in a purely additive dimension. that creativity is what you add to stuff, right? And so take, for example, this case, Meshworks, which probably many of you know, right, where then Judge Gorsuch declared that this to be insufficiently creative, a mere slavish copy of a Toyota Camry, right? And this has always puzzled me, right? I mean, he says here, right, they're just, right, it purely depicts the vehicle, right? There's untouched by the digital paintbrush, right? If here he'd painted like a palm tree or like it was climbing up a mountainside, right? Like Gorsuch seems to be requiring some sort of additive creativity here. You paint some palm trees in there, you've got a copyright. But I think what Gorsuch fails to note is that like that doesn't look at all like a Camry. Right, like if you went to the Toyota dealership, right, and you're like, I would like to test drive the Camry, and they showed you this wireframe model of a Camry that you could see through, you'd be pretty freaked out, right? Like you would not get in that car, right? It's like that doesn't look at all like a Camry, right? And I think what Gorsuch is failing to recognize is the way in which an important part of aesthetic and creative process is not purely additive, but in fact abstractive or subtractive as well. And so I think Meshworks demonstrates that. But here, right, like this case succeeds for the author, right? With this photograph of Thomas and Friends tank engines. Why? Because I made them look super happy. They're happier than they already were. I don't know, they look like Thomas and Tank Engine Friends to me. Like they look like toys to me, right? But he's able to tell a story about the way in which there's something special about these photographs of them that doesn't exist in the toys as such, right? So if you can tell a story about additive creativity, then you can succeed, right? But if your story is merely abstractive creativity, I think things tend to fail, right? Consider two examples, right? So you recognize this brilliant piece of work? This is a work of art called Glazed Maple. This is linoleum floor tile. And the plaintiffs in this case asserted copyright in glazed maple. That looks like a floor tile to me, right? That looks like a piece of wood, but that was not what they claimed. Right, they claimed here, and you should read this case, it's terrific, right? They claimed that like they looked at a lot of wood and got a bunch of ideas about wood, but that this is not any particular piece of wood that has ever existed, but rather an expression of their ideas of glazed mapleness, right? And so here what they were doing was like thinking hard about what like maple should look like, and then demonstrating it with this piece of wood that looks like what maple should look like. And there the court's like, oh yeah, like you guys did a lot of stuff. That's really creative, great, right? But here, right, when the author says like, hey, like I'm trying to interpret like, right, it's kind of a subtractive, abstracted creativity, right, I think it becomes harder to see the nature of the creativity involved in this production. Right? Or at least the extent to which the author doesn't want to tell a story about, like, I thought about log cabins, and then, like, all of these dreams about log cabins came to me, and this is what I produced, right? When the author doesn't want to tell that story, sometimes for aesthetic reasons, sometimes for market-based reasons, right? Then the ultimate copyright becomes in doubt. Right? And so you see here this quote from one of the kind of great writers on conceptual art, Saul LeWitt. With respect to conceptual art, the execution becomes often a merely perfunctory affair. The whole point is that the concept or the idea eliminates the arbitrary, capricious, and subjective as much as possible, right? And so when it comes to something like this, the Oyo sculpture, right, that's exactly the point in many respects, right, is to limit the subjectivity and creativity of the artist, but that itself is a creative contribution. Right? And so this sort of kind of challenge of understanding the relationship between the control the artist asserts over the work, right? And going back to Shyam's suggestion with respect to Sarony, right? Like Sarony gets a lot of credit there for asserting control over the work, right? And who gets very little credit? Right? Certainly Sarony's mechanic, right? Because in the 1870s, 1880s, he was called mechanic and not a photographer, right? But also Wilde, right? And more importantly, Wilde's barber, right? So not everyone knows, Wilde took his barber to the Metropolitan Museum of Art. Right? The photograph was taken while he was here in New York, to look at sculptures of the classical works in the Metropolitan Museum to make sure his hair looked exactly like that, right? And so as we think about who has control over that work, right, I think Wilde and his barber also miss out in those claims as well, although I think they may matter in important ways, right? So I think this stuff understanding this kind of challenge between control and creativity, I hope will give us some purchase on analyzing the questions associated with Slater and monkey selfies. Will give us some purchase on analyzing these questions associated with AI and computer code, right, and the sorts of creation that come about in those sorts of ways as well. So I'll leave it at that. Thank you very much for your time and your attention.
Excellent. Good morning, everyone. It is great to be here, and I want to thank everyone here at Columbia, Pippa, June Besick, Jane Ginsburg, also Cassandra Gizzo, the symposium editor of the Columbia Journal of Law and the Arts, Rachel Horn, the editor-in-chief, Samara Weiss. Everyone here has done a wonderful job of organizing this, and I am happy to be here and happy to participate in this. So, here's my title, How Much Should Being Accommodate Becoming? Copyright in Permeable and Dynamic Works. And let me start out by explaining what I mean by permeable and dynamic work. So, permeable art I'm trying to use as a kind of umbrella term for art that has weak or ambiguous boundaries, that blurs text and context. Certainly some site-specific or environmental art or land art does that. It's art that incorporates its location. Found art does that, art that incorporates pre-existing objects. And by dynamic art, I mean art that changes over time, that's unstable or fleeting or evanescent. So environmental art, again, right, if and to the extent that it incorporates decay and life and movement in nature. And performance art, right, art that consists of low deliberation, spontaneous performances, unfolding in real time. Those are dynamic art, participatory art as well, right? Art that invites ongoing contributions by visitors, all dynamic. Both of those kinds of arts, permeable and dynamic art, are art as becoming. And to understand what I mean by becoming, we've got to go back to Heraclitus and Nietzsche and the dichotomy, right, that here's a quote by Nietzsche, sort of calling on Heraclitus, suggesting that the real world is all about becoming. That is to say, it's all about change, fluidity. There's nothing really stable in the real world. Stability is something that we as human beings impose on the real world, right? And permeable and dynamic art, right, are kinds of art that in some ways are suggesting that space and time are continua, they are not discrete blocks, that space and time are populated by kind of more like fluids of viscosity in motion rather than discrete and stable objects, and stable objects and also boundaries between artist and creation and observer. Those are fictional and they deserve to be challenged, and that's what this kind of art is going to do. Right? They come up against copyright, which I want to say is committed very firmly to being rather than becoming. Right? The structure of copyright law requires a stable object of the work of authorship. We can't determine whether two unpredictably changing objects are substantially similar to each other. Nor can we determine whether two objects with indefinite boundaries are substantially similar. So the whole idea of granting exclusive rights over something when there's no thing, that's a problem, right? In spite of that, copyright as a human imaginative creation has developed a variety of, I think, quite powerful tools to accommodate permeable and dynamic art. I want to talk about three of them. One is the idea of acknowledging selection, arrangement, and transformation as authorship in compilations and derivative works. The second is the idea of copyright in ranges and constraints rather than determinate values. So the work of authorship is providing a framework. And the third is what I will call trans-category non-notational fixation. And I'll come back to what that means in case you're puzzled by that. I want to suggest, though, however, in spite of these powerful tools, copyright policies are going to end up imposing limits to the use of those tools. So let's talk about the first of these tools, the idea of permeable art, but incorporating context and pre-existing material as selection and arrangement. Here's a work by Agnes Dinas, Chained Indian Forest. This, of course, is a photograph of part of this work, right? But it is, in fact, a forest that has chains around some of the trees located in Art Park up in Lewiston, New York. Here's an Andy Goldsworthy work called Frozen Patch of Snow. This snow sculpture in a landscape. Those, I think, we can talk about as involving the selection and arrangement of the context, right? That the artist has chosen where to place those works and in some sense has incorporated the context into those works. However, right, three caveats to that use of selection and arrangement to incorporate the context. I think that the author has to either decide to claim context or not, right? That you can't leave that indeterminate in a registration application or in litigation. You can't say, I want to leave it up to the observer to decide the extent to which the site is important to my art. Secondly, I think claiming context may likely limit copyright protection rather than expand it. So, right, here's Andy Goldsworth's Frozen Patch of Snow. If the part, an important part of this work is where it's located and the fact that it is on this hill, right, then if I create a work called Goldsworthy at the Capitol and I'm using making two unauthorized uses here to create that work, right? But let's say if I actually create this work, I think it's less likely if Andy Goldsworthy says it's about the whole thing, right? That my creation, which copies now what is only part of his work, is an infringement. And then thirdly, right, I think that copyright policies will and should resist deeming the choice of the site alone as sufficient for substantial similarity, right? So here back again is Andy Goldsworthy's work, but right, suppose that I decide to create a sculpture on the same site. Do we want to say that because Goldsworthy has claimed the site that any other thing placed in that same site is likely to be infringing? I think probably not. All right. Let's talk about kind of found art, right? Of course, things that are found can be selected and arranged. And here's Tracy Emin's piece, My Bed. There's certainly enough selection and arrangement here, right, to think about authorship. You don't have to carve a sculpture out of stone in order for it to be sculpture. But now let's get to sort of more and more extreme found art. Marcel Duchamp, bicycle wheel. Well, this is at least two things that he found and put together that aren't usually found together. I think that's at the edge, right? But then when we get to another Marcel Duchamp piece of ready-mades or found art, right? Bottle rack. I think this gets to the edge, right? That's a selection of one can't be sufficient for copyright. Ranges and constraints. What am I talking about there? May remember a couple of the well-known cases involving console video games back in the 1980s, and this results in these decisions like Williams Electronics versus Arctic, right? And here's another slightly previous case from the Second Circuit, Stern Electronics, right, where the court says, well, it's true that all the sights and sounds of the game are different each time the game is played. However, many aspects remain constant, and a repetitive sequence qualifies for copyright protection as an audiovisual work. I want to think about what the court is talking about there as providing ranges and constraints as a framework, as a work of authorship, right, rather than having to depend upon determinate values. Once we think of it that way, we can actually go back in time and think about other pieces of work as actually doing that. Think about a Calder mobile, right? It is possible that this mobile will never be in exactly the same position twice. Something is rotated slightly differently than it was before. And yet, even though there's an infinite number of positions, right, we all remember from college mathematics that there are degrees of infinity, and Calder has provided ranges and constraints to constrain the infinite. Yes, there's infinity there, but it is a bounded infinity. And if we think of that as being possibly a work of authorship to provide those ranges of constraints, suddenly we encompass a lot of dynamic and permeable art. But there's going to be copyright doctrinal and policy limitations on that. Many of you probably know of the Post-Secret project, where Frank Warren invites people to send in secrets on postcards, and then he posts them online. That is providing ranges and constraints, right? It's a 4x6 card. Whatever you can do in that 4x6 card, he suggests the constraint of telling your secret anonymously. You're not supposed to put your name on there. It's supposed to be something that you have not told others. I think that comes up against the idea expression, or should come up against the idea expression dichotomy or limitation, simply because of the breadth that would, of the copyright that we would grant to Frank Warren in those ranges and constraints. Not a complex enough series of ranges and constraints to constitute a copyrightable work of authorship. Lastly, dynamic art and the idea of trans-category non-notational fiction, right? So if a work of art is in constant change, how can it be fixed? First, I want to say fixation is a matter of scale in time and space, and I think some works perhaps aren't quite as dynamic as we might think they are, and they may be fixed on appropriate time and space scales. However, when additional fixation is needed, one of the innovations of the 1976 Act is this idea of non-notational fixation in other categories of copyrightable works. But the issue of subject matter remains. So what do I mean by the possibility of fixation of dynamic works? Chapman Kelly's Wildflower Works has been mentioned before. And I think it is possible, although I'm not sure I agree with the breadth of the rationale here, it's possible that this work indeed is unfixed as a static work because it is so close-grained in space that it's not fixed for long enough time. Take a look at the close-grained nature of that composition. Compare it to other kinds of compositions in flowers. So this is a Dutch landscape architect, Nick Ruzen. He creates the Marco Polo Dreamy Flowers Park in Yangzhou in China. Right, also uses flowers. I don't know whether these are wild flowers or not, but these could be wild flowers. And yet, right, the composition is coarse-grained enough that I think it is under any traditional notion of fixation, it's fixed for more than a transitory duration. Right, but that is actually converting it into a static work. We're saying, oh, it's a static work and it's been fixed for long enough. What about more truly dynamic works? And here I want to suggest, right, this idea of being fixed in any tangible medium of expression, sometimes we think of that, oh yeah, it means paper, magnetic tape, USB, key drives, whatever. That's what it means by being fixed in any tangible medium of expression. However, what it also means is that a work in one category can be fixed in a work of another category without using any form of notation. And so what I mean by that, right, here's Garrison Keillor claiming the text of a verbal performance that he gave and that was captured in a audiovisual work. Here is Nora Jones claiming as a musical work a performance that she gave and that was captured on in a sound recording. Here's George Balanchine claiming as a choreographic work, a performance that, and it's not, right, it's not, that's Laban notation, some of you may know, choreographic notation. It's not notated, it is merely captured in an audiovisual work, right? So that sort of gives rise to a lot of possibilities for taking dynamic works and fixing them. The issue does remain, right, whether the work in question falls within a copyrightable category, or whether we, as Reagan mentioned, right, with the dance works, whether we have to say, oh no, that's just an audiovisual work. We're not looking through that audiovisual work to another category of work like choreography. So Andy Goldsworthy, he creates this ice spiral, which is, in fact, melting and will melt within the day. All we have of it publicly now is a still photograph, but suppose he records the melting on video. Do we say that that is a fixation, the video, of something called a transmuting sculpture, right? I'm just making those words up, but a sculpture that is in motion and decay and disappears, and that's part of that work? Or do we say, oh, no, sculptures by their nature as a category of work of authorship, they themselves need to be fixed and stable, and so this is not really a copyrightable category of work of authorship, right? Or what about the performance artist Nikhil Chopra? He had a project over at the Met. I happened to be there on one of the days he was performing last month, and so here's my own photograph of him performing in the Met, right? But suppose we record this on video. Do we call that improvised choreography? Is there a copyrightable work category that it falls into? Or is it an uncopyrightable performance like Cindy Lee Garcia's in Garcia versus Google? I think the whole range of issues that copyrightable subject matter and categories of copyrightable subject matter raise are very interesting, very rich. Not time for me to do it right now, but I'm happy to discuss it further. So thank you very much.
Before we start with questions, I wondered if any of the panelists had any reactions or things they wanted to add after seeing their fellow panelists. You don't have to, but sometimes ideas come up. I have a question, sort of for everyone, but Chris brought it to mind in your presentation. So one thing that's interesting about the Katie Nolan log cabin is I always thought that part of her sculpture sort of was the void that was created by the facade, and which goes to what you were sort of talking about, subtraction and addition, and how or should copyright take into account that space that's purposely left blank, so to speak, that is part of the sculpture in itself.
Yeah, I mean, I'm not sure. Did I not turn it on? I did turn it on. Yeah, look at me. Yeah, I think it's a great question, right? And I think like part of the challenge here is a challenge with respect to the limited nature of copyright claiming, right? And the difficulties of like asserting what you're claiming and what you're not claiming, right? Whereas, for example, I don't know how many of you spend any time looking at design patents, right? Design patents actually allow you to disclaim lots of stuff. and in the process of disclaiming, show the way in which you're claiming certain aspects of your creativity, certain aspects of the thing that you've designed, but not some other bunch of aspects, right? And so I think that's one benefit of the ways in which design patents work, is they help you see that which is not claimed. Whereas I think in copyright law, that just becomes really hard, right? And I think just in general, I don't know that I fault Judge Gorsuch when he was then that much, right? But he's clearly looking for stuff, right? And I think like with respect to the log cabin, right? If they're sculptures of children inside and they're playing around, right? If there's a palm tree outside the log cabin, right? Judge Gorsuch would be happy, right? The Copyright Office would be happy, I think, right? And that would be okay. But seeing the things that aren't being demonstrated actually becomes much harder. And I think this is partly why I encourage my students to be good at describing stuff, right? We have to get used to being able to articulate what it is that works of art actually do and how they do it.
Do you also want to just explain a little about the log cabin case? I don't know how familiar everybody here is with the case, so a short summary of sort of what happened in that case.
Well, there are people who are litigating that case in the audience, so it might make more sense for them to talk about it. But basically, that's a Vera case that's pending in New York, where the artist Katie Nolan, which is one of the most, in my mind, one of the most important American artists that is living today, has a Vera claim in connection with the restoration of the work and some of the logs that were replaced. Megan?
She originally asserted a Vera claim in connection with the purchaser. Can people hear me?
Yeah.
Okay. She originally asserted a Vera claim in connection with the purchaser's restoration of the work, which involved replacement of the wooden components of the work, but which left intact the underlying metal substructure, connective elements, as well as some surface elements that the artist has described as key to the work, including an American flag that was draped over the windowsill, etc. The work, interestingly, was created before the effective date of Vera, and title had transferred away from the artist by that time. So one argument that the defendants in this case have made is that the work is actually not subject to Vera protection. The case has been briefed for dismissal 3 times now, and so the plaintiff's arguments have evolved over time. In the face of an initial motion to dismiss, which pointed out this arguable weakness in the Vera claim, plaintiff shifted her argument to allege that instead of it being a Vera claim, or in addition to it being a Vera claim, it was also a more traditional copyright infringement, i.e. that the conservation of the work, which involved replacement of the logs, effectively created an unauthorized copy of the work. So the case is pending a 3rd motion to dismiss now. But as you pointed out in your presentation, Amelia, if the work is not subject to copyright protection, then it's also not eligible for Vera, completely aside from, the effective date of the statute versus the creation date of the work.
And the work was never copyrighted.
Correct. It was subject to a final request for reconsideration and denial thereof.
And so would not presumably be eligible for the bundle of rights under 106.
Correct.
I mean, I think you raised an interesting question, because one of a very creative way of producing artwork is destroying artwork. One of the most iconic works is this erased de Kooning drawing by Rauschenberg, and I'm not sure that sort of gets into the question of what can the copyright law really do and protect, and is there, to my mind, copyright law doesn't really map on very well to conceptual art, because there isn't this way of dealing with these, very important works that should merit some protection, but don't really fit.
So what is the solution, if there is one? I mean, how does one? Shyam was talking about redefining authorship. one of the big issues with conceptual art, obviously, is that the idea is a huge part of the work, and the expression is in some ways supplemental to it. How do we tweak what we have and the infrastructure that we have? Is there a way to embrace this kind of change in creativity or expression of creativity?
Take a stab at it. Look, I think part of it is it has to be holistic, right? I think one of the things we're seeing in the conversation is that it's not just one little doctrinal area here or there that is the impediment to recognizing the nature of creativity in conceptual art. It's originality, it's fixation, it's subject matter, and it's the unstated stuff. So I think what we really need to have is a full-blown conversation about the accommodation of copyright principles across the board and the extent to which the analytical roots of these principles are indeed capable of covering this. I mean, in different areas, when you have new subject matter that copyright, for instance, says we don't want to incorporate into the system, we don't want to expand the domain of our traditional principles, we go down this, in my view, inefficient route of a sui generis regime for different categories of creativity, and that produces at least a workable system. I think the concern with conceptual art is in you're something of a limbo. On the one hand, you have these analytical devices that are not capable of capturing it, but you're constantly trying to fit them in without expanding these different concepts. So I think the solution really is a question of whether copyright should protect this. Amelia, I think, begins from the assumption that copyright is the best vehicle because it is about creativity and protecting expression. And I think that the question needs to be asked whether the resistance you're seeing from these conceptual domains is a resistance endemic to the system, or is it a resistance that is just on the margins?
Yeah, and I wonder, there are people better versed in art history here than I am by far. And I wonder to what extent this is just a kind of peculiar historical moment at which contemporary artistic practice and copyright law happen to be bumping up against one another, right? It just so happens that over the course of the past, not quite century, approximately a century, contemporary artists have decided to challenge all of the things that we've historically thought art was about, right? So first that was, art is about beauty. No, it turns out art doesn't have to be beautiful, right? Art has to do with creativity. And then you see things like Sherry Levine's After Walker Evans, right? And so, or no, art doesn't have to be creative either. Art has to be about stuff, right? And then you see with the rest of the conceptual art doesn't have to be about stuff either. And so in many respects, these artistic practices are artistic practices that are interesting precisely because they are challenging our fundamental conceptions of what authorship and creativity and all of these things that copyright law is built on are. That may stop soon, right? After Sherry, so Sherry Levine, do you know this work? After Sherry Levine did this work After Walker Evans, which is a photograph of a rephotographing of one of Walker Evans's famous photographs, right? So you can imagine what comes next, right? The next thing is After Sherry Levine, which is a photograph of Sherry Levine's photograph of Walker Evans, right? But at that point, the joke is over. Right? There's not an after Sherry Levine, right? You don't want to do that too many, right? And so in some respects, right, it might be that we have now, gotten to the bottom of all of these aesthetic principles. We've decided, no, it's not about creativity, originality, or authorship, or any of that stuff. And then, people will just go back to making art in all sorts of other ways. And, right, it won't, right? And, this interaction between copyright law and contemporary art will, seem quaint, right, 50 years from now.
I guess I do think that there is a limit, and the limit has something to do with claiming exclusive rights, wanting to claim exclusive rights in something that you say is boundless and constantly changing and, is authorless. Copyright does grant exclusive rights. That is what somebody wants when they are trying to claim the benefit of exclusive rights. And those exclusive rights do presuppose some object that can be the basis of those rights. And so if you really are challenging to that extent that you say, my creation is boundless and is constantly changing and so forth, then it's kind of difficult to use copyright, and it's kind of difficult to claim that exclusivity for that.
So hypothetically, if you take Kelly and you take the Ruzin Marco Polo work, do you, just show of hands, who thinks that the Ruzin is copyrightable? The Ruzin is the one in China.
See, all these folks could not look up slides, unfortunately it was, yeah.
Okay.
That was more flowers. It was just like more flowers.
It was flowers, but it's flowers in a recognizably large-scale graphic composition.
And more dense.
Like the Mickey Mouse at Disneyland.
Okay, got it.
You know, that versus a Kelly.
I think both.
I think both.
Both. Okay. So are they different, or are they the same? In the sense that one has a much more fixed goal of representation and a much more representative. Is that? I think that is probably the more striking thing, is that one is meant to look like X and one was much more free form. And should that matter? Is that?
I mean, yeah. I mean, so like partly this is the challenge of like lots of visual art, as we've like in the photograph cases that weren't discussed here, right? Kaplan and others. Like lots of visual art's not about anything, right? Like this is among the other sorts of things that happened over the last 100 years. Visual art doesn't have to be about anything but art. And so it becomes about aesthetic practice. It's not representational in any meaningful sort of way, right? And this becomes the challenge of taking concepts that were derived mostly for literary expression and then applying them to musical expression or visual art, right? So the idea-expression dichotomy, right, works really well if you're talking about a script for A.B.'s Irish Rose. You can ask, what's it about? And then you can ask, how is that aboutness expressed? And then it works really badly for lots of conceptual visual art because it's about its place in the historical record, right? It's about contemporary aesthetic practice, right? It becomes really hard to understand, right, that whole, like where we are along this spectrum of ideas and expression, precisely because it's not about anything, right? It's not about a particular kind of it's not about representing X, right?
So in a situation, say Mickey's head at Disneyland, which they take great pains to make sure that it always looks like Mickey's head. And if a flower dies, I bet they're on it in like 6 seconds, right? But is that something that is permanent? I'm trying to distinguish something like that with a Kelly. And from the Copyright Office perspective, right? Or from someone who would potentially deny a Kelly because of Kelly's copyright because of a fixation concern. Is that true for any floral display, or is it only true for floral displays that might not have the plan and the upkeep? And Jeff Koons's topiaries were copyrighted, as I recall. But eventually they had to die too. So is that a derivative? Is a dead Jeff Koons topiary a derivative work of the original?
I mean, we don't look at like the half-life or how long something is going to last when we look at the fixation requirement. If it is stably fixed, we might register it, and that would be true for something where the material is made out of plants as well. So I mean, that would be the standard we'd be looking at if we were looking at Mickey Mouse. And we would also say this is Mickey Mouse, and maybe, you know, figuring out what were the new original, I guess it would be in the form of the material used, since there's Mickey Mouse registrations already.
So if Kelly, I guess my question then is, okay, so if you know that it's going to have 600 red tulips and 400 white tulips, then it's fixed, even though it might change when they die, or but then Kelly was 800 wildflowers that changed over time.
Right, but I mean, at least from my perspective, one of the problems with that view of wildflower works was that it was such a fine-grained composition that it is possible that from minute to minute, as the wind blew, the yellow flower standing next to the pink flower was now east of the pink flower, and then it was back west of the pink flower, because it's a very fine-grained composition, right? Well, you can't say that about Mickey Mouse or about the Reason work in China, right? So thinking about it as, did the design exist for more than a transitory duration? If we're thinking about it as a graphic design, it's quite possible that the Wildflower Works did not exist as a graphic design. It was so fine-grained that as the wind blew, those flowers were fluttering back and forth, right? That doesn't happen with the Marco Polo world or with Mickey Mouse's head.
But what I'm hearing from Reagan, and I don't want to put words in your mouth, is that that level of transitory analysis, was the wind blowing eastward or westward, is not something that would be considered during the registrability question. That they simply ask the nature of the medium, and if there's some sense of permanence or non-transitory revelation, that's sufficient. Which you don't have to answer, Reagan, if that's.
I don't really know about Kelly, the Seventh Circuit opinion in terms of that. That is the court's logic, but I mean.
It's not the court's logic.
Well,
I'm just making it up.
You're filling in a way to have it make sense. So, but I mean, yeah, we will look to see that there is enough of a stable fixation,
right.
And I mean that may be a reasonable way of looking.
I mean, the reason why I think I'm going to disagree with you a little bit, Bob, is I think Kelly was an authorship case masquerading as fixation.
Yep.
Right? I think part of what the premise of Kelly, which fits into the point I was making, is the court didn't have a vocabulary of authorship to fully grapple with, is the nature of human agency involved in this artwork the kind that copyright law considers creativity and worthwhile being protected? Had nothing to do with, I mean, I think all this stuff about the transitory, and they have this language, I think, in the Seventh Circuit opinion, the essentiality of the medium being an additional element in fixation. I think that goes to show that this is an effort to try and introduce something altogether new that didn't have anything to do with fixation. So which brings me back, Pippa, to I think that both the Mickey Mouse and Kelly would be copyrightable under a fixation standard. The question then becomes, should we think of them differently from an authorship point of view? Then we ask, do we have a different conception of authorship? Is the amount of control you exercise over nature something that we should think about in terms of our domain of creativity? Completely different from anything that was articulated by the Seventh Circuit.
The court should read our papers.
And I have one last question before we open it up. Amelia, you were talking about whether or not copyright registration achieves the goals that the artist wants. And sometimes if copyright ability is an issue, you can address it through private contracting. And I wondered if you thought that private contracting was a poor substitution for the rights guaranteed under the Copyright Act, or whether it was a real way of achieving goals, and what goals one could achieve realistically in terms of putting restrictions on a purchaser in terms of distribution or resale or anything like that.
I mean, I think it really depends on the artist. I mean, some of these artists can command what they want in their agreements and can afford lawyers to write that up for them. But I think the problem is that there are a lot of other lawyers who can't afford that and don't have the wherewithal to do that. And so I think, I raised the cases of Ai Weiwei and of Anish Kapoor to show a sympathetic case, of the consequences of not having copyrightability is what can an artist do when their artwork is in a car ad, is being infringed, but it's not copyrightable? Why is a significant work of art entitled to less protection than, for example, the paparazzi photos that I have to defend, media companies against copyright infringement cases for those all the time? And so I think it can be a substitute, but it's definitely not a perfect substitute.
Do we have any questions from the audience? David?
took the position that anything living was, not capable of being copyrighted. So in your example, Pippa, at least in the Seventh Circuit, you couldn't copyright the Mickey Mouse or the thing in China that Bob showed. So
it said that, but you do wonder
Yeah.
if it was presented with the the Mickey Mouse or the Marco Polo world, well, it would come out a different way, and it may well have to do with authorship as well as
But
fixation.
my question for the panel really is that, in part, isn't this really about compensation and not, so much theory of copyrightability? Because, the example we used in our amicus brief in the Kelly case was, if I took a photograph of the wildflowers and somebody then took my photograph and put it on a T-shirt, the irony is I could sue them for copyright infringement, but the original author of the work, who the Seventh Circuit said was not an author at all, gets nothing. And I think that's really the problem with some of these cases, which is maybe what we ought to be thinking about is the compensation model and not so much necessarily, the theory. Because after eBay, even if Wildflower was copyrightable, you probably couldn't get an injunction anyway. So the issue really is one of compensation, I think, and I'd like to hear what the panel thinks about that.
Well, I think the VARA context of Wildflower Works really distorts what's happening in that case and what the court is doing, right? If we had an actual infringement case where what Chapman Kelly was arguing was that another oval-shaped garden somewhere else in the world was infringing his Wildflower Works, then we'd have some very interesting discussion about, well, that oval shape, that's just a basic geometric figure. That can't be right. Those square things inside, those were vents for the garage that's underneath. That's not part of it. Now let's get down to thinking about the actual patterns of the flowers and whether those two can somehow be described as substantially similar. And we'll think about authorship too, right? But that's a very different framework than the VARA framework. So to the extent you're talking about compensation, and what you mean is the scope of the exclusive right in an infringement case, Kelly never was able to get into that because that's just not the context.
For what it's worth, I think Kelly probably was pretty well compensated. I take it, right? They paid him a bunch of money to design a bunch of flowers and plant a bunch of flowers, right? And so presumably sufficient to actually get him to do it, right? I mean, I don't know exactly what the nature of his relationship was with the Chicago Park District, but I take it they gave him some money or at least said, hey, please do this, right? And so he's like, all right, sure, I'll do that, right? And so at least to the extent that what we're trying to do is to incentivize creativity via copyright law, we seem to have gotten the creativity that Chapman Kelly wanted to produce and that the Chicago Park District wanted to host. So it's, to me, these questions they become differently difficult if what we're trying to do is figure out whether copyright actually should be protecting these sorts of things, right? So I think the basic way that most of us, or at least the three of us at the end, we're thinking about them was more or less purely theoretically. What does copyright mean when it thinks about authorship and creativity and the like? But I think you have raised an important point. What should we be doing with any of these things, right? I have written that I think the sort of creativity that chefs produce is entirely conceptually worthy of authorship in copyright law. Do I think that chefs really need copyright protection? No. Do I think chefs even want copyright protection? By and large, no. So the whether copyright law is a good idea is separate, I think, from the whether copyright law could plausibly work here in a doctrinal or theoretical matter.
And that may turn out to mean that a copyrightable subject matter approach is the best approach to address those kinds of issues, right? That a garden or food, no matter how much from authorship or fixation perspectives we think is eligible, yeah, but those have sufficient other incentive structures that we don't think we need copyright law.
Right.
We think that the game isn't worth the candle.
Since 1790, what's been protected by copyright law has never been the full scope of potential copyrightable authorship, right? At no time has copyright, even in the 1909 Act, where they said all the writings of the author, they then said, we don't actually mean that, we mean these particular writings, right? So it's always been only a subset of constitutional authorship and constitutional writings. And I think it remains only a subset of constitutional authorship and constitutional writings. I think that's good, but.
Can I just go back to David's? I think you make an interesting point, but I'm trying to disaggregate your question when you're saying that it's more about compensation than copyrightability. What I take you to be saying, at least in the way you describe the argument in the amicus brief, is that it's an element of fairness here, more than just thinking about the way in which we're giving someone exclusive rights. And if you disaggregate what exactly is going on there, I mean, the irony is whether the photograph, the closest it is to the actual wildflower arrangement, in and of itself should be the subject of copyright, right? I mean, to the extent that it is the equivalent of product photography that is just an ordinary production, then we get into the big muddle of whether the work that was being done in the Seventh Circuit opinion was around originality rather than fixation, even though it's couched as something of a blend between the two. So I think the question of fairness is indeed a genuine one in terms of the bright line rule of copyrightability or not, but it goes back to the conceptual muddle that we have, and this time we just shifted from fixation to originality on the photograph side.
Yeah, well, the Seventh Circuit said it was not a work of authorship. So, I mean, that is the issue, right? And so beyond the VARA issue, right, is in our brief we said we're not weighing in on the VARA question. We're weighing in on, we think there's an error by the district court, and then when it went up on petition for cert to the Supreme Court, we're weighing in on this question of authorship, and we think the court got it wrong on authorship, even if the result under VARA would be the same. And so I think, again, it is really an issue of, I think, fairness, but also separating out the question of authorship from fixation or from a right you might have under VARA.
What about, speaking of VARA, what about the idea of separating VARA from copyrightability? And saying that you get those rights, they're true moral rights, and you get them whether or not the work is deemed copyrightable by the Copyright Office.
Well, I mean, I think that was a consequence of baking it into baking moral rights into the Copyright Act, and so that is one of the requirements under the statute. But if you read Kelly, you also see that, I mean, the Seventh Circuit certainly takes the view that it's only a subset of what's copyrightable that's actually protectable under VARA. It has to be, a pictorial, graphic, or sculptural work is subject to copyright. But in Section 106A, it talks about a sculpture, a painting, which is a different concept than a work that's just copyrightable. So I think if you look at that, if you look at what the court said in the Kelly case, that's intentional, and that's what the copyright law and the U.S. law should cover. But that is a much more limited subset of what even is copyrightable.
I mean, it's a very interesting theoretical point, which is, can you think of should you think about it as a category of works that are not copyrightable and eligible for 106 rights, but only 106A rights? I don't know the feasibility of working that system pure and how that would work, but I think it gets to something that you've written about too. Fundamentally, the tie-in between 106 and 106A has been an American artifact ever since the historic rejection of moral rights, and so the extent to which that could be functionally realized, I don't know.
Well, I think you'd have to take it out of 17.
Sorry?
I think you'd have to take it out of the
Title
copyright.
17.
Yeah, and create a different category that didn't tie those two together. But I'm just thinking of ways that an author who might not fit in the contours of a traditional copyright would still have some rights that they could exercise that are true moral rights, in that they are not based on any legal regime, but they are part of the artist at his or her core.
Sure, and I think then you'd ask the question, do you need a different conception of authorship for those works that are eligible for moral rights as opposed to the ones that are going under 106.
Yeah, Shyam, it all comes back to you and authors. So write a
Always.
really good paper because it could be the basis for just entirely. So what about the idea that people have put up of having foreseeability as a sort of a standard? We see what the artist could foresee happening and take that into the application process. So it is, the artist knew that this wood was going to rot, and so should have foreseen that there would be replacements and and then it can be copyrighted because deterioration or whatever was a foreseeable event.
Right, so I guess at least one of the questions we should be thinking about again is, and this was kind of beginning to emerge, is the relationship between validity and scope. Right, and so are we asking this as a question of, is there enough foreseeability and predictability that we think there's a valid copyright here? Right, that can be one question. If the answer to that question is yes, then we can have a subsequent question, which is like, what is the scope of the predictability or variation or unforeseeability with respect to other potential infringing works? Right, and those two don't have to be exactly the same thing, especially to the extent that copyright infringement, the 106 rights, don't protect just identical copying, right? They also protect substantially similar copying. And so we could cash these out in both validity and in scope. I don't have strong theories about what to do, but I just want to point out, you could do it either way or both ways.
I mean, from a Vera perspective, there is an exclusion under Section 106A for restoration. I mean, I think the issue is there aren't a lot of cases on Vera, and most of them are saying that the law doesn't apply. And so we don't really have a good understanding of what are the contours of that exception. But to me, it shouldn't relate to the issue of copyrightability.
Jane.
I wanted to pick up on copyrightability and scope because it seemed to me, looking at Oyo, that that was plenty copyrightable, that there was a choice as to the color, the size, the font of the letters, the kind of reversibility of the representation. And so I was wondering if lurking behind the rejection was some concern about whether protecting IO would end up protecting the idea of a sculpture like that. But it seems to me that one can recognize that there is sufficient creativity, which doesn't mean that there isn't a thin copyright in the result. And so I think a better outcome would have been to recognize the originality, but also recognize that the author's rights are not going to extend beyond much more than authorizing or refusing to authorize photographs of that sculpture and potentially VARA claims. And I wonder, particularly with works of art, whether we're in most cases we're really not talking about a market for multiples, as you said. We're talking about the preservation of the object or possibly photographs, but we're not so much worried that people are going to be popping up IEO sculptures all over the place. And the last observation is that VARA is woefully incoherent because it is not really a moral rights statute, and it's not really an arts preservation statute. It's a very unsuccessful engrafting of the two, and so it will be difficult to make a great deal of sense out of it. But I want to go back to my challenge on whether the real problem with IEO and perhaps some other rejections had more to do with the scope of protection or concern that if the work is registered, it will be overprotected and therefore bad for other artists. And so that's a bit of the tail wagging the dog.
I was not at the office for OYO, and I have to admit I would have to look at what was said, but I think there may be some truth there in that the office is, I think, very, takes a lot of pains to ensure for lettering specifically not to grant a registration that would extend to typography. The 76 House report, of course, notes this is something Congress could consider later on, but we're not doing it now, so I think the office is very careful in looking at that, but I'm not familiar with, the specific placement in the OYO going backwards and forwards, so that might be something to consider. And I feel like I'm looking at Karen and should note that we have our moral rights report, which came out, which talks about VARA, but also other ways in which the U.S. law tries to accommodate moral rights on an international. So that might be also interesting in this conversation, although I'm not right now prepared to get into the other things in that report.
Janet?
Thank you. I just wanted to pile on to what Jane said. I quite agree that the thin copyright in IOYO might have been a much better approach. But let's remember that Love, Robert Indiana's work, was not copyrighted, and copyright.
No, it was registered back in 1967. Registered.
It was.
Yeah.
Well, then the same. Why then? What's the difference? Why? How? I mean, two letters instead of 4, but he had great difficulty enforcing that if it was registered because he was not able to get license rights from the many copiers of him over the years.
Well, he made it for the post office, which I think complicated matters because then it became a stamp which could be used in various,
But there were, maquettes and posters and calendars and other cities and, small, large, different colors, all sorts of variations. And my understanding was that he was not compensated for any of that. So again, just I guess going back to Jane's point, I think it would have been much better to have granted a limited copyright on that. Thank you.
I will say a lot of times we will do that, not being familiar with those specifically, but we will, in a review board letter, say, we have looked at this, we think your specific articulation and expression of these elements is over the line and exposes the modicum of creativity, but we will say in that, which we are making public, that we think it is a thin, sort of in an effort to signal the office's views on the scope of that copyright when it gets out there in the public.
I mean, keep in mind again, this is what happens at the PTO with design patents, right? If you try to assert something, then they say, well, you're going to have to change your claims a little bit, right? And they're going to make you modify your claims until you've got a claim that can both clear the bar, but is not drafted at too high a level of abstraction, so that it suggests that you're going to be able to claim an awful lot of design, right? And this is just one of the curious quirks of copyright law. That we I think it's awesome that the Copyright Office is doing something that's kind of like what the PTO is doing with respect to design patents. Is they're trying ex ante to kind of ratchet up and down the scope of protection, right? And I think that's a terrific, because I think it helps solve precisely this problem, right? Because otherwise it's like, if we toss this to courts, if we toss this to people who then get to write a bunch of demand letters, maybe we're nervous they're going to start suing, people making red on nose sculptures, right? And we don't want them to be able to sue people making red on nose sculpture. I assume that we don't think that on no would be covered by an OEO copyright. Right.
Yeah,
So
I think there's really something in that because we register so many compared to what courts see, and the registration department will sometimes then annotate the office's views of limitations, or we may say that in a review board letter. You are, I think, a lot of correspondence is clarifying the scope of the claim, and there is a disclaiming process. It's not the same as design patents or the patent and trademark systems. Generally, there's no opposition procedure. It's a different system. But there is some of that work happening in what's going on through the office's prosecution of these copyright claims.
I think that's great.
I have to say I was surprised when I saw the refusal of the Oyo sculpture. I think that a lot of practitioners would have assumed that would have been copyrightable. And, you know, as the comment of artworks not being copied, I mean, that may be true to a large extent, but it does happen. I mean, there is a pending case by an installation art collective that there's a copy of that installation work. And so if that's not copyrightable, then what's to stop someone from, you know, doing the same artwork but not under the same name?
Josh?
In Kelly, the court essentially assumed that a work of visual art would be is nested inside of the 102A definition of copyrightable material. They sort of say, okay, there's this list, and PGS works is in there, and a work of visual art is a PGS work. But the definition of a work of visual art is completely separate. You know, when we were talking about its paintings, its sculptures. And so theoretically, you'd have sort of a Venn diagram where there are copyrightable works, some of which are works of visual art, and some that aren't. And my question is, when the Copyright Office is refusing copyright registration on the basis of something like fixation or originality, would they consider creating a list of works of visual art that are not meeting the definitions under 102A, but otherwise meet the requirements of work of visual art in the 101 definition, which might provide some clarity to people who are trying to bring claims under 106A, which similarly does not address originality or fixation? And you don't have to say, yes, we're going to do that, but I'm just sort of curious if that's something that's been considered, or because I don't necessarily think the statute provides that work of visual art is subsumed within copyrightable subject matter.
I think it is.
Did you want to?
Well, a definition of a work of visual art says if it's not copyrightable, then it's not. Any work not subject to copyright protection under this title is not a work of visual art. So, but I think it would be interesting to know what are the works that are copyrightable, but are nonetheless not subject to not a painting or a sculpture under the definition of 106A. Barbara?
Yes. I'm a little bit confused by your discussion, Professor, especially. I work with a number of artists that you showed images of and have successfully.
I think there's some confusion when you're talking about the VARA issues as it relates to copyright and the idea of works, for example, like a Goldsworthy or some other artists who work in performance, where the documentation of the image may be in the form of a photograph. And what you're protecting in the photograph is an image. If somebody recreates that image in some form, that is, in my view, an infringement of copyright because you are reproducing the image in another medium. So I'm a little troubled by the discussion of non-copyrightability because it really seems to be fixated on the work of art as opposed to the image.
Yeah, well, no, it is very important, I think, to notice that some environmental artists' business model is actually photography, right? And photography. In other words, that Andy Goldsworthy does not make most of his money off of snow. He makes most of his money off of selling the photographs. And if you take a look at the photograph of the ice sculpture, what strikes me is what care has been taken in arranging that as a photograph, right? The sculpture is backlit. It's standing in front of a background that's in shadow, and so it's absolutely true that Andy Goldsworthy's photos are protected regardless of whether there's a work that's depicted in them is protected. And if somebody copies that photograph that I showed you, hopefully my use is fair use, so I just want to insert that here, but right, hopefully if somebody copies, displays, or otherwise infringes the exclusive rights in that photograph, then Goldsworthy absolutely has the right to claim infringement, right? But for purposes of this panel, I wanted to go sort of further and say, well, let's take Goldsworthy kind of even more seriously and ask if it's not the photograph he's looking for protection for, but the sculpture, or whatever it is, the transmuting sculpture, could for a video or a photograph be seen as a non-notational fixation of that other work, which we're going to then protect.
The guru himself.
I don't know about that. I have a couple questions, and this arises from comments Sean made about differentiating between authorship in the conceptual art and fixation. So the first part of the question is, with respect to authorship in conceptual art, do members of the panel think that this is a situation like we experienced under the 1976 Act, where Congress looked at the question of, was the current conception of dance being protectable as a dramatic work sufficient, or did we need an entirely new category of authorship of choreographic and pantomimes to better protect things like modern dance that didn't necessarily tell a story as dramatic works did? And so the one option would be to have Congress, help solve this problem by creating a wholly new category that would better fit these sort of concepts of conceptual art, performance art, things like that. Or alternatively, I think what Congress left open is for the courts to define the scope of the existing categories to broaden those. I see Bob smiling. This goes back to something else.
I am smiling because we have an ongoing disagreement about the interpretation of 102A, but that's
well, fine. But even so, I mean, could create a new category or define the scope to say, okay, one of the existing categories does include some of these areas that maybe courts had been treating more narrowly, or that the Copyright Office had. And so that's the first part of the question. Secondly, I think just on the other side of the issue in terms of fixation, and what Bob, you mentioned last about the photograph of the ice, does seem like the Copyright Office would accept for sculptural works, we accept ID material of sculptor works. We don't want you sending your 3D sculptures to the Copyright Office. So photographs or illustrations will suffice. So in that case, you could fix, if you were claiming it'd be helpful if you distinguish between whether you're trying to register the photograph as a photograph or 2D art versus the 3D art. But if you are claiming the 3D authorship, to what extent do you think do we need to capture that melting element in there, and to what extent does that sort of fit within what you had mentioned about the video game cases, where it doesn't capture every iteration of the video game, but the courts had seen, well, basically the code there, captures every possible iteration, so that although we don't know how it's exactly going to work out, that has been sufficiently fixed.
Well, the deposits in the video game cases were actually videos, right? They were not still photographs, they were videos. And I think the courts there thought that was important because part of the protection that the owners of copyright were claiming was in motion characteristics. It was not simply statically the way the video games would look at any particular still moment, but how those little ship representations moved across the screen, right? At what, those are the kinds of ranges and constraints that were in motion. And, the same thing may be true with a Goldsworthy. Is Goldsworthy claiming not a 3D, but a 4D work of authorship, right? So he's actually claiming something that has to do with the rate of deterioration and the way that the work is deteriorating. Or is he just claiming a 3D work of authorship? For a 3D work, and I think that the Copyright Office has kind of assumed that sculpture is only 3D, and therefore a 2D representation will suffice. It doesn't need to capture the time element. In the video game cases, they wanted the time element protected, and that's why they submitted videos, not still photographs.
With respect to the first question, I don't know where you both end up on this side of the debate. So I'm joining whoever thinks like 102A is a fairly closed category.
That's his side.
Okay, right. So good. I think 102A is a fairly closed category, and to the extent that we're going to add something to it, Congress should be the one who does it. My general, and I think like fashion design becomes a fairly helpful example of how this went, right? Like there are some fashion designers who really, really wanted intellectual property protection. And then when they pushed for it, it turned out there were an awful lot of other fashion designers who really, really didn't want it, or who had very different ideas for exactly what it should look like. And those debates became, they were aired in Congress when Congress had an opportunity to consider them. And so I think, right, like to the extent that a chef comes forward and says, I really want copyright protection for this dish because I'm really angry about this particular bit of copying, right? I think like I'm more worried about this, the sensitive plaintiff there, right? And the appealing plaintiff being able to make an argument to a court that doesn't incorporate the externalities of incorporating copyright protection for recipes or whatever, right? So my general sense is like, if we're going to expand the 102A categories, Congress should do it, and it should do so by trying to listen to all of the affected players, including consumers.
Yeah, I think that might be right as a matter for legislative concern, right? The only problem textually with that is that 102A says including before it has that list of 8, and then it actually there's a definition of including in section 101 that says the term including is illustrative, not limitative. And you put those two together, it's really hard to suggest that there's no possible copyrightable work of authorship outside the limited categories. Now, I don't think that prevents you from saying, okay, but we need to use a kind of a justum generis approach, and there are certain things that are either like or not like the limited categories, and we'll use that to limit it. But just as a textual matter, it's very hard to say that it's only those 8 when you read the text and the definition of including.
Just in quick rebuttal.
Yeah.
The legislative history is very clear that the reason, as I just mentioned, that they were reserving unto themselves the ability to create new categories, so that it wasn't like in the former 1909 Act where it was all writings of the author, but that they were leaving it to courts to determine the scope of any of those existing categories. And I think one thing we have to consider too is that we're not limited to any one category. So more and more, particularly in digital works and other forms of works, we're seeing cross-category works. So that's something to consider as well.
I think that what Chris said about fashion was raised a point that has been striking me in probing some of these really interesting questions about what the law should and how the law should accommodate some of these uses, if it should, is that when you're looking at copyright not from just a sui generis scope of protection, it is touching much more than the types of conceptual art and artworks that we talk about. We would register things like blasting that are just purely commercial, that are software, that are marketing materials, trade show booths, and just thinking through these questions, not just from the angle of the art perspective, but also what effect that would have on software and other areas of copyright would be an important consideration if either doctrinally through the courts or through Congress, this scope would shift.
Okay, we have time for, I think, one last question. Chris.
That's okay. No, better for them.
Sorry. I'm Cheryl Fung from Australia. Just had a proposal, I guess, a proposed argument about justifying the protection of that photograph, the Goldsworthy ice photograph. So you mentioned that he's making money through the photographs as opposed to the sculpture, but perhaps bringing it back to justifications for copyright, you could say that we provide copyright in order to encourage them to make the work public or publicly accessible so people can enjoy it. Then you would argue that we should provide copyright for that sculpture, because the alternative would be to just, go to a secluded place, create that sculpture, and then, make the photograph and just profit off that photograph. But if you want them to make it in a public place and that others enjoy it, then, copyright, should provide that level of protection. So I'm keen to hear your, everyone on the panel, your views on that. Thank you.
I mean, I don't know. I like that argument. I was certainly not arguing against protection for the sculpture. I was suggesting ways in which copyright might accommodate protection for the sculpture itself. Although it does turn out that I think Goldsworthy, most of his creations are done exactly as you say. They are done more or less in private places and photographed, and then the photographs are marketed. There are some that are public, but not many.
Chris, do you want to have the last word?
I wanted to ask a question.
Oh,
Is that, can I ask a question from the Copyright Office? Good, so,
I can't hear as well.
in the reading material are the rejections of Log Cabin and Oyo. And one of the things that struck me in reading the rejections is that the Copyright Office decided to base all of its judgment about the failure in the second criteria of Feist and not the first, right? So what they say is the author asserts that these are original, which is to say not copied, and we accept that. But, right, they fail under the second category, the second criteria of they're insufficiently creative because, right? And I guess I wonder why the Copyright Office doesn't push back on the first one rather than the second one, or at least to say something like, that log cabin that you designed is copied from all of the log cabins that have ever existed, right? Like, not entirely, right? And it has variation from those log cabins, but at least with respect to the basic outline of the log cabin, it is clearly copied from all of those log cabins. It also, I think, then uses a bunch of not very creative shapes and squares and angles and the like. But I was wondering why the Copyright Office doesn't say anything about originality, like the not copied component, rather than just and puts all the emphasis on the creativity component.
I just want to interject real quickly because there's a lot of page turning. Those rejections are part of the materials that are available online. So if you're interested, you go to the website and it will direct you to where those materials are available. And also copyright rejections are available on the Copyright Office website. I'm sure you're going to get more hits than you've ever had. So if you're interested in exploring further, anyway.
Yes, please explore further. You can also see all of the briefs the government has filed in copyrightability and decisions of the Copyright Review Board. So, and we have a fair use index that provides, in layman's terms, all the fair use cases. But to get to your question, I don't know that we would get to a different outcome if we were to look at the first and second prongs. Definitely, I think how generally these letters go is that under the first standard, it is, are you the person who has done the thing? And then secondly, is the thing that you have done sufficiently creative? And so if you're, I think it's where you're kind of putting the verbs, but it is easier to just do that analysis under the creativity issue. But you're still looking at, is this all the log cabins or the standard? It's very hard to say, like, what is a chair? If you take away image 3 instead of 4, that's still a chair. But in the case of that specific sculpture, it made more sense to have the analysis at that place.
Yeah. Also, all I'll suggest is that although it may not matter so much for the ones you reject, it may matter for the ones that you accept, right? To the extent that you're actually including in the language something like, we think that this is not entirely original, right? So for the ones you reject, they're out of the copyright system, it doesn't matter at all. But for the ones that are accepted and then potentially asserted against others, it might be helpful to have something in the step 1 analysis where you say, we actually think a lot of this is copied.
Well, I think one thing that is interesting is we are discussing whether to include correspondence, sort of prosecution history in the new registration system, which in some ways, that can be interesting looking at it from a trademark perspective.
Copyright wonk's dream,
what has
boy.
happened. What's that?
I said that would be a copyright wonk's dream to have, as you in the trademark, trademark and patents have the prosecution history, have it all available.
Yeah, I mean, we're an office of copyright wonks, so, we appreciate the impetus for that. You can already get that if you request it, and obviously we're undergoing a process to make things more digital, but I think it's tricky to really subject the copyright registration process to the same examination standard one might get a patent. It doesn't make sense to do that given how the copyright system works, but I think there is something there in that you can see the office saying, this is the thing we focused on when we granted the registration, and it's the presumption of validity does not necessarily mean the Copyright Office has blessed certain other pieces, which may or may not be original to that, or may just be something you've used and amassed into the copyrightable work.
That's helpful.
So I want to thank everyone. We are at lunch, which I know you will all use to go to copyright.gov and explore, but you only have an hour and a half. We will see you back at 1:15. And you don't need to sign out if you're coming back in the afternoon. I think you can just sign out for CLE once.